Hello everyone and welcome back to our YouTube channel Lawyer Stuffs. This is Pragyanjali and today we will be discussing about the first fundamental right, that is right to equality under Article 14 of the Indian Constitution. To understand Article 14, let us first try to appreciate what is rule of law. The concept of rule of law was propounded by A.V. Dicey in his book The Constitution of England. It basically means any person, whether rich or poor, the servant or the owner, or the government or the governed, all are equal in the eyes of law. They all should be given equal treatment. According to this concept, there is always a supremacy of law, or simply we can say law is above everyone. This concept of rule of law is variable in the Constitution of India, firstly in preamble wherein it is written equality of status and opportunity, and secondly in Article 14. Now, if we read Article 14, it states that the state shall not deny to any person the equality before the law or equal protection of the laws within the territory of India. So basically, there are two concepts in the Article 14 which we need to understand. That is equality before law and equal protection of laws. So first concept is equality before law. It is an English law concept and is negative in approach. This concept is very general in nature, which ensures that law treats everyone equally and prohibits unequal treatment. The perfect example of this concept is Lady Justice, who is blindfold, which means that in the eyes of law, everyone is equal and at same pedestal. Next is equal protection of laws. It is an American law concept and is positive in approach. It is specific in nature and has no universal application, which means that it is not necessary that law should be applied equally to everyone in all circumstances. For example, there are two people, a male and female. We can't treat them equally on all circumstances. For better treatment, we need to differentiate their needs and classify them to give equal treatment. On this basis, if special laws are made for women for their protection and safety, that will not be violative of Article 14. For public welfare, classification is needed, whether it is on the basis of gender, caste, status, then only better laws can be made. So, it is now clear that for public welfare, classification is a must. But to protect this classification from undue advantage, a test was formulated in the case of State of Bombay versus F.N. Balsara. This test has two conditions, that is, intelligible differentia and rational nexus. Intelligible differentia. Intelligible differentia means that when you are differentiating between two groups, then a valid and intelligible reason should be assigned that on what basis you are differentiating between these two groups. And rational nexus. It means that whatever is the purpose of classification and the desired result means what has to be achieved from that classification, there should be a nexus between them. Or simply we can see that there should be a rational relationship between the desired result and the classification. So, everything discussed till now was an old doctrine which was used till 1970. Supreme Court found this concept of equality very negative and restrictive in approach. So, in the case of E.P. Royappa versus Tamil Nadu, Supreme Court formulated a new doctrine and said equality is a dynamic concept. It cannot be crimped, confined or cabined within the traditional limits. With the change in society, the needs of the people will also change. Then new principles and laws will be required to meet those challenges and requirements. This new doctrine is dynamic concept of equality and activist in approach, and it also expands the scope of equality before law and said that equality before law will also include the principles of natural justice. The same view was adopted in the case of Maneka Gandhi versus Union of India, and it was held that the sole purpose of Article 14 is to strike out arbitrariness from state action and ensure fairness and equality. If any action is arbitrary, then it is for sure against equality. Then it does not matter whether the action is qualifying the test of equality or not. So this doctrine targets arbitrariness and supports reasonableness. And lastly, and most importantly, in Article 14, the term any person is used, which means this right to equality is available to both citizens and non citizens of India within the territory of India. I hope the concept of right to equality is clear. For any query, comment down below. Thanks for watching and do not forget to like, share, and subscribe.